Hello and welcome to another lesson in corporate law. This lesson deals with the meaning and importance of the Memorandum of Association, Articles of Association and Prospectus. It also discusses the various clauses of Memorandum of Association. In addition, the lesson also explains the meaning of ultraverse. The significance and importance of prospectus in corporate law is also explained in today's lesson. I am Amrita Ghoshkumar and the subject expert for this lesson is Dr. S. Miraj, teaching in the Amity University. Let us begin with understanding the concept of Memorandum of Association, Articles of Association and Prospectus. Memorandum of Association. Memorandum of Association is one of the documents which have to be filed with the Registrar of Companies at the time of incorporation of a company. Section 2 of 28 defines a memorandum to mean the Memorandum of Association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this Act. The definition, however, either does not give us any idea as to what a Memorandum of Association really is, nor does it point out the role which it plays in the affairs of the company. The Memorandum of Association is an extremely important document in relation to the affairs of the company. It is a document which sets out the constitution of the company and is really the foundation on which the structure of the company is based. It contains the fundamental conditions upon which alone the company is allowed to be incorporated. A company may pursue only such objects and exercise only such powers as are conferred expressly in the memorandum or by implication therefore, that is, such powers as are incidental to the attainment of the objects. A company cannot depart from the provisions contained in its memorandum, however great the necessity may be. If it does, it defines its relation with the outside world and the scope of its activities. The purpose of the memorandum is to enable shareholders, creditors and those who deal with the company to know what is the permitted range of the enterprise. It defines as well as confines the powers of the company. It not only shows the object of its formation, but also the utmost possible scope of its operation beyond which its action cannot go. Lord Keynes in Ashbury Railway Carriage Company, v. Rich, pointed out, the memorandum is, as it were, the area beyond which the action of the company cannot go. Inside that area, the shareholders may make such regulations for their own government as they think fit. Purpose of memorandum. The purpose of the memorandum is twofold. One, the intending shareholder who contemplates the investment of his capital shall know within what field it is to be put at risk. Number two, anyone who shall deal with the company shall know without reasonable doubt whether the contractual relation into which he contemplates entering with the company is one relating to a matter within its corporate objects. At least 7 persons in the case of public company and at least 2 in the case of a private company must subscribe to the memorandum. The memorandum shall be printed, divided into consecutively numbered paragraphs and shall be signed by each subscriber with his address, description and occupation added. The presence of at least one witness who will attest the same. Contents of memorandum. According to section 13, the Memorandum of Association of every company must contain the following clauses. 1. The name of the company with limited as the last word of the name in the case of a public limited company and with private limited as the last word in the case of a private limited company. Number 2, the state in which the registered office of the company is to be situated. Number 3, the objects of the company to be classified as A. The main objects of the company to be pursued by the company on its incorporation and objects incidental to the attainment of the main objects, and B. Other objects not included above. Number 4, in the case of companies with object not confined to one state, the states to whose territories the objects extend. Number 5, the liability of members is limited if the company is limited by shares or by guarantee. Number 6, in the case of a company having a share capital, the amount of share capital with which the company proposes to be registered and its division into shares of a fixed amount. An unlimited company need not include items 5 and 6 in its memorandum. In the case of a company limited by guarantee, its Memorandum of Association shall state that each member undertakes to contribute to the assets of the company in the event of its being wound up while he is a member or within or year afterwards for the payment of the debts and liabilities of the company. Every subscriber to the memorandum shall take at least one share and shall write opposite to his name the number of shares taken by him. Different clauses. A brief discussion of the various clauses are as follows. Name clause. A company may be registered with any name it likes, but no company shall be registered by a name which in the opinion of the central government is undesirable, and in particular which is identical or which too nearly resembles the name of an existing company. Where a company is registered by a name so similar to that of another company that the public are likely to be deceived, the court will grant an injunction restraining it from using that name. Every public company must write the word limited after its name, and every private limited company must write the word private limited after its name. The use of the word company is, however, not compulsory. Companies whose liabilities are not limited are prohibited from using the word limited. The words limited may be dispensed with the name of charitable companies. But companies formed to promote art, science, religion, and so on, which do not propose to pay dividend but intend to apply all its profits towards the working of the company, can be registered without the word limited under licenses granted by the central government. A company cannot adopt a name which violates the provisions of the Emblems and Names Act 1950. This act prohibits the use of the name and emblems of the United Nations and the World Health Organization, the official seal and emblem of the central and the state governments, the Indian national flag, the name and pictorial representation of Mahatma Gandhi and the Prime Minister of India. If a limited company makes a contract without using the word limited, the directors who make the contract on behalf of the company would be personally liable. Every company is required to publish its name outside its registered office and outside every place where it carries on business, to have its name engraved on its seal, and to have its name on all business letters, billheads, notices, and other official publications of the company. Registered Office Clause. This clause states the name of the state where the registered office of the company is to situate. The Registered Office Clause is important for two reasons. Firstly, it ascertains the domicile and nationality of a company. This domicile clings to it throughout its existence. Secondly, it is the place where various registers relating to the company must be kept and to which all communications and notices must be sent. A company need not carry on its business at its registered office. A company shall have its registered office Such office must be in existence from the date on which the company begins to carry on business or within 30 days after incorporation, whichever is earlier. Notice of situation of the registered office and every change therein must be given within 30 days from the date of incorporation of the company or after the date of change, as the case may be. Objects clause. The objects clause is the most important clause in the Memorandum of Association of a company. It is not merely a record of what is contemplated by the subscribers, but it serves a twofold purpose. A. It gives an idea to the prospective shareholders the purposes for which their money will be utilized. B. It enables the persons dealing with the company to ascertain its powers. In case of companies which were in existence immediately before the commencement of the Companies Act 1965, the Objects Clause has simply to state the objects of the company. But in the case of a company to be registered after the amendment, the Objects Clause must state separately. A. Main objects. This subclause has to state the main objects to be pursued by the company on its incorporation and objects incidental or ancillary to the attainment of the main objects. B. Other objects. This subclause shall state other objects which are not included in the above clause. Further, in the case of a non-trading company whose objects are not confined to one state's clause, must mention specifically the states to whose territories the objects extend. The subscribers to the Memorandum of Association may choose an object or objects for their company. There are, however, certain restrictions. 1. The object should not be against the policy of the Constitution. For example, the object should not be such as to encourage untouched ability which has been abolished under our Constitution. Number 2, the object should not include anything which is illegal or against public policy. For example, forming a company for dealing in lotteries or for trading with the alien enemies. Number 3, the object must not be against the provisions of the Companies Act, as for example, authorizing the company to purchase its own shares. On its being registered, the company has the power to do whatever is necessary for attaining the objects stated in the memorandum and to do whatever else is incidental to or consequential upon the attainment of the main object. It is therefore clear that any act of the company outside its stated objects is ultra vires and therefore void and cannot be ratified even by the whole body of shareholders. Liability clause. This clause states that the liability of the members of the company is limited. In the case of a company limited by shares, the member is liable only to the amount unpaid on the shares taken by him. In the case of a company limited by guarantee, the members are liable to the amount undertaken to be contributed by them to the assets of the company in the event of its being wound up. However, this clause is omitted from the Memorandum of Association of Unlimited Companies. Any alteration in the memorandum compelling a member to take up more shares or which increases his liability and would be null and void. If a company carries on business for more than 6 months, while the number of members is less than 7 in the case of public company and less than 2 in case of a private company, each member aware of this fact is liable for all the debts contracted by the company after the period of 6 months has elapsed. Capital clause. The memorandum of a company limited by shares must state the authorized or nominal share capital, the different kinds of shares, the authorized or nominal share capital, the different kinds of shares and the nominal value of each share. The capital clause need not state anything else, and it is usually better that it should not do so. Association or subscription clause. This clause provides that those who have agreed to subscribe to the memorandum must signify their willingness to associate it and form a company. According to Section 12 of the Act, at least 7 persons are required to sign the memorandum in the case of a public company, and at least 2 persons in the case of a private company. Doctrine of Ultraverse. Ultra means beyond, verse means powers. So the term ultraverse means beyond the powers of the company. A company exists only to carry on the objects which are expressly stated in the Objects Clause. It means the company can perform those objects only. It can also do such acts which are incidental or consequential to the specific objects of the company. A trading company has implied power to borrow, and this power need not be stated separately. This doctrine has been first explained in the leading case of Ashbury Railway Carriage Company Limited versus Ritchie L.R. HL 653 in 1975. The object of the company as contained in the Memorandum of Association has been to make, sell or lend on hire railway carriages and wagons of all kinds to carry on the business of mechanical engineers and contractors. The directors of the company, however, have contracted for financing the construction of a railway line in Belgium. The company has endorsed the Act of Directors by passing a special resolution in the general meeting. However, the contract has been held to be ultraverse of the objects of the company because the word general contractors does not authorize the company to make contract of every description. The doctrine has been confirmed by the Supreme Court in Lakshman Sami Mudaliar versus LIC of India 1963 AIR section 1185. An act done outside the express or implied objects is ultraverse. The ultraverse acts are null and void ab initio. The object of the ultraverse doctrine is to protect the interests of the investors and creditors by ensuring that the company does not invest or utilize the money in those acts which is not contemplated by the shareholders or creditors of the company. Effect of ultraverse acts. 1. Void ab initio. These acts are void right from the beginning. 2. Injunction. A member of the company can bring an injunction, order of the court refraining to do against the company to prevent from proceeding with the ultraverse act. Number 3. Personal liability of directors. The directors of the company may be personally held liable to outsiders for those ultraverse acts. This is made on the ground of breach of warranty or authority. Number 4. No ratification. If an act is ultraverse, the company, it does not create legal relationship. It is a violation of the law and diversion of the assets of the company to purposes not contemplated by the members and creditors of the company. As it is an act outside the powers of the company, even the whole body of shareholders cannot ratify it and make it binding on the company. Number 5. Company can neither sue or be sued. The company cannot sue the contracting party. Equally, the contracting party cannot sue the company. Various types of ultraverse acts. It is necessary to distinguish the acts outside the powers of the company and board of directors. Acts made beyond the scope of Memorandum of Association cannot be ratified by the company even by the total body of the shareholders as they are outside the powers of the company. However, if the acts are only beyond the powers of the directors but within the powers of the company, those acts can be ratified by the company. Capital clause. In the case of a company having a share capital, the capital clause has to state the nominal or authorized capital of the company. The nominal capital is divided into different classes of shares. The capital clause has to state the values of the different classes of shares such as equity share capital and preference share capital and their division into shares of a fixed amount. In the case of a company limited by guarantee, the amount promised by each member to be contributed by them in the event of winding up of the company is to be mentioned. Liability clause. The liability of the members is limited to the extent of the shares subscribed by the members of the company in the case of a company having share capital. It means no member can be called upon to pay more than the nominal value of the shares held by him or the amount remaining unpaid. In case the shares are fully paid, the liability is nil. In the case of a company by guarantee, the liability is limited to the extent of guarantee given by the members. This can be called only when the liabilities exceed the assets of the company. Subscription or association clause. In the case of a public company, at least there must be 7 subscribers, although 2 are sufficient in the case of a private company. All the subscribers must sign the Memorandum of Association. Each subscriber must take at least 1 share in a company. Normally, the Declaration of Association reads like this: We, the several persons whose names, addresses and occupations are subscribed, are desirous of being formed into a company in pursuance of the Memorandum of Association and respectively agree to take the number of shares in the capital of the company set opposite of our respective names. After incorporation, no subscriber can withdraw his name on any ground whatsoever. Articles of Association. Articles of Association lay down the rules and regulations framed for the purpose of its internal management of the affairs of the company. They facilitate the way for carrying out the objects specified in the Memorandum of Association. Relationship between the Memorandum of Association and the Articles of Association. 1. Ranking. Articles of Association is subordinate and controlled by the Memorandum of Association. Number 2. Subordinate. The Articles of Association are subordinate to the Memorandum of Association. Articles of Association cannot contain any provision which is inconsistent with the Memorandum of Association. Articles of Association may supplement the Memorandum of Association. Number 3. Scope. The Memorandum of Association lays down the scope or powers of the company, while the Articles of Association govern the way in which the objects of the company can be carried out. As regards the contents, Articles of Association resemble a partnership deed. Adoption of Table A. A public company limited by shares may have its own Articles of Association. In the absence of its own Articles of Association, the company can adopt Table A. In other words, preparation of Articles of Association is not compulsory. Even if Table A is adopted, if the company's Articles of Association is silent on any matter, provisions of Table A would be applicable. Contents of Articles of Association. Some of the contents of Articles of Association are as under here. 1. Allotment of shares. 2. Procedure for transfer of shares. 3. Powers of directors. 4. Forfeiture of shares. 5. Common seal of the company. 6. Accounts and audit. 7. Voting rights and proxies. The Articles of Association spells out the way the affairs of the company would be conducted. Alteration of Memorandum of Association and Articles of Association. Alteration of Memorandum of Association is much difficult and strictly regulated. Articles of Association can be easily altered by passing a special resolution in the general meeting. Prospectus. A prospectus is a document or a publication by or on behalf of a corporation containing information on the character, nature and purpose of an issue of shares, debentures or other corporate securities that extends an invitation to the public to purchase the securities. The content of a prospectus is regulated by federal law. It must contain all material facts relating to the company and its operations so that a prospective investor can make an informed decision as to the merit of the investment. A prospectus must be furnished to an investor before any purchase is made. Prospectus is a detailed statement by a corporation required when there is an issuance of stock to the general public. A prospectus includes the financial status, the officers, the plans, contingent obligations such as lawsuits of the corporation, recent performance and other matters which would assist the potential investor or investment advisor to evaluate the stock and the prospects of the company for profit, loss or growth. Objectives. Prospectus is issued with the following broad objectives. It informs the company about the formation of a new company. It serves as a written evidence about the terms and conditions of issue of shares or debentures of a company. It induces the investors to invest in the shares and debentures of the company. It describes the nature, extent and future prospectus of the company. It maintains all authentic records on the issue and make the directors liable for the misstatement in the prospectus. Contents. The following important matters are included in the prospectus. The prospectus contains the main objectives of the company, the name and addresses of the signatories of the Memorandum of Association and the number of shares held by them. The name, addresses and occupation of the directors and managing directors. The number and classes of shares and debentures issued. The qualification share of directors in the interest of directors for the promotion of the company. The number, description and the document of shares or debentures which within the 2 preceding years have been agreed to be issued other than cash. The name and addresses of the vendors of any property acquired by the company and the amount paid or to be paid, particulars about the directors, secretaries and the treasurers and their remuneration. The amount for the minimum subscription. If the company carrying on business, the length of time of such businesses. The estimated amount of preliminary expenses. Name and address of the auditors, bankers and solicitors of the company. Time and place where copies of balance sheets, profits and loss account and the auditor's report may be inspected. The auditor's report so submitted must deal with the profit and loss of the company for each year of 5 financial years immediately preceding the issue of prospectus. If any profit or reserve has been capitalized, the particulars of such capitalization will be stated in the prospectus. We will see you soon with another topic of corporate law. Till then, take care and bye-bye.